Hello, thanks for joining us. Welcome. 10 years ago, on February 25th, the U.S. Supreme Court reminded us that the Sherman Antitrust Act should perhaps be aimed at the biggest anti-competitive force of all, government itself. Nearly 20 years ago, North Carolina Board of Dental Examiners targeted shopping mall teeth whiteners. These were non-dentists offering a conventional service. The board issued over 45 cease and desist letters, pressured the state's Board of Cosmetic Arts examiners to do the same, and urged mall managers to evict these businesses. Their motive? They were protecting their own turf, as 8 of the 10 board members are licensed dentists. By redefining dentistry to include teeth whitening, they forced competitors to either spend years and thousands of dollars to get a dental degree or shut down. On February 25th of 2015, the Supreme Court called out this shakedown, ruling that licensing boards dominated by active market participants without legislative oversight were acting like private cartels, using government power to stifle competition. One would think the states would have reformed their boards in the last decade, but they haven't. In fact, a new report by Cato's Stephen Slavinsky and Pacific Legal Foundation attorneys Caleb Trotter and Joshua Polk found most dental boards remain unchanged, some even more dominated by industry insiders. And it's not just dental boards. 85% of the 1,700 U.S. occupational licensing boards across the country still require a majority of members to be active professionals. It's effectively allowing industries to regulate their own competition. In today's discussion, we'll revisit the Supreme Court's NC Dental decision. We're going to discuss our speaker's recent paper on the matter, and we're going to explore the use of antitrust law as a tool to break up licensing cartels and look at other potential remedies. So let me introduce our speakers. First, Caleb Trotter. Caleb is a senior attorney at the Pacific Legal Foundation, where he litigates on behalf of individuals and small businesses fighting for their constitutional rights to equal protection and economic opportunity. Among other things, in Caleb's practice at PLF, he leads an initiative to end race and sex discrimination in appointments to state boards and commissions. He also currently represents a Southern California surf instructor in a case raising an antitrust challenge to a municipal monopoly on paid surf instruction on beaches within the city. Joshua Polk. Joshua rejoined the Pacific Legal Foundation Sacramento office in 2019 after completing a summer clerkship in 2018. He practices within several of PLF's litigation areas, including economic liberty and property rights. Joshua was raised with an appreciation of individualism and skepticism toward overreaching government. He earned a JD from the University of Alabama Law School, and during his time in law school, he was the editor-in-chief of the Alabama Civil Rights and Civil Liberties Law Review. In this position, he hosted several liberty-focused events with topics ranging from criminal justice reform to equality in education. Finally, Stephen Slavinsky. Stephen is a senior fellow at the Cato Institute. His research focuses on barriers to economic growth and opportunities at the state and local level. He has published first-of-its-kind research on the influence of occupational license burdens on immigrant entrepreneurs and how licensing hinders the ability of those leaving prisons to integrate into the labor force and earn a second chance. His work in these topics has been widely cited by journalists and scholars, as well as the White House report on occupational licensing issued by President Obama's administration in 2015. Prior to rejoining Cato, Steve was a director of budgetary studies at Cato from 2004 to 2007. He was a deputy director of strategic research at the Pacific Legal Foundation and a senior research fellow at the Center for the Study of Economic Liberty at Arizona State University. So, that out of the way, let's get at it. Caleb, would you please give us your thoughts?
Thank you, Tad. So to start off, I'm going to take us back to the 90s. And no, we're not going to Portland, where my co-panelist's uniform would be out of place. We're going to go back to the days where if you wanted to get your teeth whitened, you basically had one option, and that was to visit your dentist. Because of that relative exclusivity for the process of teeth whitening, dentists were, of course, able to charge relatively high fees and costs for the procedure. Now, fast forward, roughly a decade or so into the early 2000s, because of the relative simplicity of teeth whitening, and after all, it's basically just a simple peroxide solution and a small UV light, non-dentists began to offer this service in shops and booths around the country, and for a increasingly significantly lesser cost. That, of course, led to more and more people getting their teeth whitened. And because of the increasing loss of business and lowering of price for teeth whitening, dentists understandably began to complain with losing the exclusivity of that process. Now, unfortunately, for at least in the point of view of myself and my co-panelists, dentist complaints didn't just stop at bemoaning the general competitive change, but they also started directing those complaints at various state dental boards around the country. I think it's telling not only in North Carolina, which is, of course, one of the main focuses of today's talk, but also nationally. Generally, those complaints didn't really have anything to do with public health or safety concerns with non-dentists performing teeth whitening. It was basically all about the competitive change and the loss of business. And that was understandable because dentists were taking in a relatively hefty source of income from that. In what we'll get to shortly is the North Carolina dental lawsuit. At least at the time, 8 of the 10 dentists who sat on the dental board at the time were earning substantial income from teeth whitening back then. So it's understandable then that North Carolina Dental Board specifically took these complaints of dentists in the state very seriously and began looking into this supposed problem of non-dentists performing teeth whitening. And even though state law didn't really touch on teeth whitening, say that it was the practice of dentistry, which would have, of course, given the dental board authority and jurisdiction over this problem, they decided to act anyway. And as Tad mentioned earlier, this included nearly 50 cease and desist letters across the state of North Carolina to non-dentists performing teeth whitening. My favorite bad fact of this is what Tad mentioned. This even included sending letters to malls, shopping malls, whose tenants included teeth whiteners, and basically told them they should evict them. And regardless of the dental board's authority to do this, it had the desired effect. And within a couple of years, non-dentists had stopped performing teeth whitening in the state of North Carolina. Well, this got the attention of the United States Federal Trade Commission. They did their own investigation, and the result of that is that they determined that the North Carolina Dental Board was in violation of federal antitrust laws. They proceeded through the process internally within the FTC to come to that legal conclusion as well. The Dental Board appealed that to the Fourth Circuit Court of Appeals and eventually to the United States Supreme Court. And so when the case got to the United States Supreme Court, cert was granted on one narrow question, and that was basically whether a state occupational licensure board, as kind of a hybrid creature of state government, was immune from federal antitrust laws. Now, there's a U.S. Supreme Court case from 1943. It's called Parker v. Brown. That's kind of the seminal case that established that state government entities are immune from federal antitrust laws, primarily due to federalism concerns. Now, the U.S. antitrust laws pretty clearly establish a policy of free market competition and encouraging that, regardless of how that has actually been enforced and acted upon. I know that's the subject of much debate, especially in libertarian circles, but let's just assume that is the policy. But I think we all know that that's not exactly the policy in the states. States themselves are the predominant limitations of competition, particularly in the professions by way of occupational licensing itself. So clearly the states are able to limit pure laissez-faire free market competition and do so without antitrust liability. Generally, the preferred in our system of government way of addressing that is through the democratic process. Whereas if you're unhappy with particularly anti-competitive policies in a given state or municipality, the way of addressing that is through the legislative bodies, not through the antitrust laws in court. So that's kind of the background of what was at stake with the North Carolina dental case. Of course, as we've kind of alluded to, licensure boards are not quite the same as state government. They're certainly not like a state Department of Health, for instance, where you've got an appointed or elected director, and then all of the staff of that agency are state employees. That's kind of the inherent agency of government. But a licensure board is very different from that. Usually, the members who make the governing decisions are typically either appointed by a governor or elected by members within the profession. They do this in their capacity as volunteers. The staff can be just private citizens. I think there's currently a controversy brewing in Alabama over there's a number of licensure boards that completely outsource the management of the boards to private companies. So they're definitely a different creature. And so that creates different problems due to, or at least different concerns over this lack of democratic accountability should the board engage in anti-competitive actions, as was done in the North Carolina dental case with these cease and desist letters. So when the Supreme Court is taking on the North Carolina dental case, it's considering whether a state licensure board, which in particular is dominated by active market participants, as the North Carolina Dental Board was, with a significant majority of the members of the board being practicing and licensed dentists. In that instance, then, in order for the board to claim immunity under the antitrust laws, they're going to have to satisfy a two-part test. And that's whether the anti-competitive actions, so in this case, these cease and desist letters, are being done through a clearly articulated state policy. So if, for example, state law in North Carolina had said, yes, teeth whitening is the practice of dentistry, then that's starting to look like a clearly articulated state policy to displace competition. Interestingly, in the North Carolina dental case, though, the parties just assumed that factor was met, even though teeth whitening was not expressly included in the definition of dentistry, but they just assumed so. And so for future cases, that is still a question that there are some intricacies and nuances to be sorted out. But at least for now, we'll leave it at the very least, that is still one of the factors that a state board would have to satisfy to obtain immunity from an antitrust lawsuit. The second factor, and that's what was really discussed at length in the North Carolina dental case, was their active supervision. And like I said before, the reason this is a key component is because if a state or a municipality is displacing competition, there's at least theoretically a democratic accountability measure available to the voters to either vote the people out who enacted that, or more direct democracy means. So that's at least an avenue. But when we're talking about a state licensure board, that's just not present at all for members of the public. And so in order for a state licensure board to claim immunity, they need to be able to show that their anti-competitive actions were clearly supervised by an officer or body of the state with actual accountability measures. That the Supreme Court, clearly notes that in the decision in North Carolina Dental that there were no supervisory measures at work at all in that case, so they didn't have anything specific to review. So they went through several examples as essentially just examples of what they're looking at, but mainly from a what it isn't. And so for supervision, there has to be a measure for one of those democratically accountable bodies or officials to actually be able to review this and disagree, and so basically overrule that decision. And that's kind of primarily the main factor, aside from they can't also be an active market participant themselves. And so because there were just no measures to review at all in the North Carolina case, again, future cases might need to build out what that exactly looks like. But one example I know of specifically that may or may not have satisfied that, but was clearly done in response to the case was Oklahoma. The Attorney General at the time, Scott Pruitt, before he became President Trump's first EPA administrator, in response to this decision, he said, okay, state licensure boards, if you're going to take any kind of disciplinary action or pursue matters against non-licensed parties, then you first have to send whatever that is, either a cease and desist or some kind of um, prosecutorial document. It first has to go to a special unit in the Attorney General's office to review that, and they can disagree, they can modify that, whatever, but that's at least going through that body. That process was never challenged as being sufficient or not, but subsequent attorney generals stopped doing that in Oklahoma. But that's just the kind of example of what would be required going forward. But as I know my co-panelists will get at in what has changed since then, those are the kind of things that a licensure board post North Carolina Dental is going to have to be showing in order to avoid antitrust liability and getting sued. And with that, I'll turn it over to my co-panelists.
Yeah, thanks,
All
Caleb.
right.
I'll take it from here because yeah, thanks, Ted. And thank you for everyone for joining in on the call today to talk a little bit about this, because we think it's a pretty important issue. And one thing that is worth pointing out, and then really I like to quantify things. I'm the economist here on the panel. Ted's an economist as well. So we're 50-50 economists and lawyers here. I wanted to look at, as my co-panelists did with me, at what the dental boards look like 10 years after the NC Dental decision. Now, luckily, this is somewhat easy to quantify because you basically count out the number of seats that active market participants, as defined by the Supreme Court, have on the dental boards. And so we looked at what the law was like. And of course, these are all statutes. It's a requirement that these people be on these boards. It's sort of built in to the mix a conflict of interest, frankly. And that's, of course, one of the things that the Supreme Court identified. But if you look at what the boards looked like in the year before the case was argued, or rather, sorry, before the case was decided, and then now we look at it today, 10 years later, what do the boards look like? Well, the too long didn't read version of this is that very little has changed. I think virtually nothing has changed. No state laws have changed to really decrease the control of dental boards by active market participants. In fact, 3 states, Georgia, Michigan, and North Dakota, actually increased the numbers of dentists. Georgia, rather very recently, the past couple of years, did this. So since the NC Dental case was decided, no states have gotten better, and 3 states have gotten worse. Now, the average seat share for the market participants on all boards in the aggregate, the average is about 85% majority. Now, bear in mind, you only need about a 50% majority, right? A simple majority to actually do things on a board. And here we're at 85% as sort of the average. Now, no single dental board had less than a 67% majority of active market participants. Again, a super majority. So even the, quote, best board by this metric still had a substantial super majority on their board, their dental board. Now, what about the other board seats? Now, those are usually awarded to members of the public. And the idea here is to have some kind of diversity of opinion, a few people on the board who may not have, and probably shouldn't have, and won't have by some statutes, this conflict of interest, this vested incentive to try to keep out competition. There's a few problems with this. Now, as a practical matter, some of these seats can go unfilled for years. So again, it's part of the governor's job to appoint people in these seats, but sometimes they can't find someone from the public to sit on these boards. Sometimes there's political pressure not to fill them, but they can go unfilled for years. Now, we've also got, as a standard kind of bureaucratic procedure, something you might be familiar with called quorum rules. It basically says, well, you can't start the meeting without a quorum being present. It's a very simple thing. Even someone who is on an HOA knows what a quorum rule is. Well, most quorum rules just simply require a simple majority to start your meeting and go about your business. Well, of course, again, as we pointed out, public members are nowhere near a majority in this case. And so you can actually just start doing the thing you want to do as a board and steamroll the agenda, even if a public member is in the room, because quorum rules don't really help create any of this diversity of opinion. Now, also bear in mind, remember those states I talked about before that didn't improve things. You've actually got 4 states that have 100% active market participants on their board. Alabama, Mississippi, Tennessee, and Wyoming have 0 public members on their board. That is by statute. There are no board seats set aside for public members on the boards in those states. So in this one-sided board composition is really a national trend, as Tad and Caleb have already mentioned. We've got over 1,700 occupational licensing boards across the country. It's important to look at that in a broad sense, because the incidental decision was only geared for dental boards, although that was, of course, the case in question. The types of rules, the types of conflicts of interest that we're talking about are endemic, built in to the DNA of these boards in all occupations. Now, one thing that is not really talked about, was not talked about in the NC Dental decision, but is a very real part of how this process works at the state level, is who do you put on those boards? We've already said the attributes they need to have. In most cases, it needs to be, mostly industry active market participants. But even those members can't be directly appointed by the governor without the say-so, in a lot of states, from the active market participants themselves. So here's what I mean by that. If you're a governor and you're going to appoint someone to, say, the Commission on the Arts, or some kind of more mundane sort of thing than, say, a licensing board, maybe they don't have any regulatory powers, they're simply an advisory board. The governor can put the name forward, state legislature will do the confirmation process, and they're on the board. They can start running their meetings. Well, the way the board process works and nomination process works for licensing boards in at least 8 states for the dental industry, and others will have different restrictions, you actually can only, as a governor, appoint someone who appears on a list that is provided to you by, say, maybe the American Dental Association, or maybe the state version of that trade association. So that 8 states actually require the governor to only choose from a list of people that are provided to them by these active market participants. Those states are Alabama, Kentucky, Louisiana, Maryland, Mississippi, North Carolina, South Carolina, and Wyoming. You might notice there's some states that appear on this list. Remember, I told you before that there's a few states, 4, that had 100% active market participant dominance on those boards. Well, Alabama, Mississippi, and Wyoming also not only have 100% dominance, it also says the governor cannot appoint anyone that doesn't appear on the list provided to them by the same people they're going to be regulating. So there's some very deep capture going on in Alabama, Mississippi, and Wyoming. Now, this won't necessarily be a problem if the boards were just merely advisory. But as has already been alluded to, these boards have a lot of power. They have more than just advisory power. They are judge, jury, and executioner, frankly, of about 1/5 of most state workforces, because licensing laws are not really enforced the way most other state laws are enforced. It's this quasi-governmental body that's been delegated the power by the state legislature to do the things that they do. And usually what they try to do is protect their turf, not the public. They'll typically try to box out competitors because of these very deeply ingrained conflicts of interest. So, good news is, I think that there are a number of statutory, meaning legal, legislative reforms that can be made to licensing boards. And at least I've got 5 that I want to talk about today very briefly. 4 of them pretty much go directly to, actually all 5 do, but 4 of them might be considered more incremental, sort of looking at the guidance that was provided by the Supreme Court in the NC Dental decision to try to make them more, not just accountable, but also less replete with these conflicts of interest. And then one big reform at the end that I think would solve a lot of problems, just even beyond the NC Dental questions. The first idea is to institute more active legislative and executive branch oversight, as Caleb has already mentioned. This can't just be a periodic check-in. It can't be during a sunset process where they do some cursory financial review and then decide to rubber stamp the agency, or the board rather, for another 7 to 10 years. It needs to be something more active. Maybe a state attorney general might actually have the ability to veto some kind of witch hunt or enforcement action, or shakedown of a specific competitor in that industry. They're more active legislative or executive branch oversight could go part of the way toward alleviating some of the concerns that the Supreme Court had in the NC Dental decision. Another idea would be reducing the number of board seats that are set aside for industry members. Even below a simple majority, it's hard to really rationalize why they have to have a majority in the first place. I mean, they're going to already have the ability to influence the judgment and the decisions of the licensing board just by being on that licensing board that has that power. Some boards actually have a majority of public members. Non-industry members are in the minority. Arizona and California, for instance, has a cosmetology board. Both states have a cosmetology board that have more public members than private sector, or more specifically, active market participant members. And that's something maybe states could look at. I'd also change the quorum rules. I think the idea that you can't start a meeting or even carry on an enforcement action without that quorum existing, you'll have to have at least one public member in the mix. That would obviously be a problem for states that have that 100% dominance, but that obviously needs to be changed too. And then finally, in the fourth incremental reform, changing the nomination process. Give governors the power they have across the board for all other types of commissions and boards. Let them decide who they want to put on the board, because maybe they have a dentist in mind who's actually more reform minded. Maybe they think the licensing process actually doesn't serve the benefit of consumers or of dentists. And maybe that kind of person wouldn't ever get through a filter from the American Dental Association, but they might actually be the right person for the board. Give the governor the actual ability to do that the way they have constitutionally for all other boards. But finally, and here's the big reform. It might sound radical. We can talk more about it during the Q&A if you like. I think we should just eliminate licensing boards as we know them. We can at best make them advisory, because we already have a state Department of Health, for instance. We already have many states actually do a similar version of this where the boards are just advisory. The actual licensing, administration, enforcement, it's being done by a traditional constitutionally required executive agency board. And so Department of Professional Regulation could do the same kind of job. A lot of states already have something like this and say their Department of Commerce. So you can strip down the enforcement powers, make them advisory. And then that would actually not only solve a lot of the problems in NC Dental, but it would also solve a lot of the public interest, or I should say the conflict of interest that we see generally. And there's a lot of other political questions that might get resolved by something like this too. But again, we'll talk about during Q&A if you like. But I'd like to go ahead and make sure I give Josh some time to talk a little more about the kind of litigation strategy and what pro-liberty litigators and legislators might want to be thinking about now that we're 10 years past the NC Dental decision. So thanks all for listening.
All right. Good afternoon to everybody, and good morning to those on the West Coast like me. As Tad mentioned, my name is Josh Polk, and I'm a colleague of Caleb's over at Pacific Legal Foundation. What we've been talking about today, to me, is more than just an interesting research project. Rather, I believe the NC Dental decision presents both a litigative and legislative pathway to rein in overreaching boards, enhance economic freedom, reduce the barriers of entry into various industries that stifle innovation and entrepreneurship. And this is sort of an untapped opportunity, particularly when it comes to the public interest legal arena. As Caleb talked about in his presentation, there have been very few cases presenting antitrust challenges to board behavior after NC Dental. And as far as I know, none of those few cases came out of public interest. I will try to keep things brief in the interest of time, but I did want to lay out in my presentation a bit of a legal strategy here that can also be used for leverage for litigative strategies that Steve just laid out in his presentation. So under NC Dental, state regulatory board can be held liable for antitrust violations if it's dominated by market participants and then also doesn't meet the necessary standards for immunity Caleb outlined, and I'll go into a little bit later. But what does it mean to be dominated by market participants? Unfortunately, the Supreme Court did not provide a rigid test. However, we do know that if market participants have veto power, control board decisions, or a simple majority on the board, or otherwise exert undue influence on regulatory actions, the board could be dominated by market participants. This matters in practical reality because many licensing boards, particularly where industry insiders have outsized control over agency actions, act less like impartial regulators acting for the benefit of the public and more like private clubs protecting their own financial interests. But that draws the question, who do we sue? For a potential antitrust lawsuit, it's important to strategically select targets vulnerable under the standard. As discussed at the beginning of this presentation, the field is ripe with captured boards targetable under antitrust law, and with the sort of research that Steve did and Pacific Legal Foundation did, we're sort of developing the keys to identifying those worst offenders. Those boards that are the most dominated by market participants, like the dental boards, have been since before NC Dental and continue to be 10 years later. So we have to ask a couple of key questions. So very simply, does the board have a majority of industry insiders? Or do those insiders exercise disproportionate control over enforcement actions? Once you ask those questions, hopefully in the affirmative, and you've identified a vulnerable board, litigation should then focus on the two prongs that Caleb talked about briefly in his presentation: clear articulation of state policy and active supervision by some state agent not a member of or not an active market participant in the regulated industry. The Supreme Court has not had very many opportunities to define the contours of what it means for an anti-competitive policy to be clearly articulated by the state, but it has provided some limited guidance. For example, anti-competitive behavior must be foreseeable from the state's grant of authority. Beyond that, just general authority to act, such as regulate in the interest of the public, is not enough. Rather, there has to be clear evidence that the state anticipated that the challenge policy would displace competition. Most often, that's going to come in the form of a specific grant of authority through statute, but boards often push their luck when it comes to actually using the power that they're giving, engaging in things like licensure creep, unsupervised cease and desist campaigns like took place in the incidental case itself, and stuff like that. So even where a statutory grant of authority exists, it could still be worthwhile to examine whether the board is stepping beyond that grant of authority and applying overburdensome regulations or engaging in really heavy-handed enforcement tactics. The second way to get at board anti-competitive behavior is to determine that there is no active supervision by the state. As with clear articulation, the court has not been exceedingly clear about what this means, but it has made clear that this is just not a rubber stamp requirement. State supervisor, often AG's office or governor's office, must actually review the substance of an anti-competitive policy and have the power to put a stop to it to satisfy this element of the immunity analysis. I'm not going to get much into the merits of an antitrust claim, but obviously once you defeat immunity, you still have to win. And so you have to prove the merits of your claim, essentially establishing that there was an agreement to restrain trade by board members, either explicitly or implicitly. These days, particularly after incidental, boards are a little smarter. It's rare for colluding parties to explicitly lay out their plans. So litigators will often have to rely on circumstantial evidence and patterns of behavior to show that anti-competitive behavior is having an effect on the market. So ultimately, antitrust litigation could allow liberty litigators to remove power from interested regulators and decision makers and stamp out particular anti-competitive behaviors, but litigation is not the only tool. As Steve talked about a little bit already, legislative reform can be more durable and immediate. We can push for changes that clarify board power, increase accountability, and ensure that boards are not self-regulating monopolies, which is how they operate now. The potential for liability can be used as leverage to persuade state legislators to address anti-competitive board composition. One Louisiana congressman recently publicly stated that most of the state's regulatory boards could be subject to antitrust scrutiny because of how much power industry insiders exercise with almost no accountability from disinterested state agents. And that legislator went on to encourage reform. So this is, I think, possible to use the litigation strategy to also achieve legislative wins as well. It's a bit of a review of what Steve proposed, but some key reforms could include stricter definitions of board authority. Many boards claim enforcement powers that statutes don't explicitly give them. Clearly defining the powers could prevent them from overstepping their bounds or make them easier to sue when they do. Second, state legislators could impose stricter active supervision requirements. State legislators should require substantive, ongoing oversight of board decisions. This can involve moving boards under the auspices of another executive agency or requiring agency heads to approve board actions. Next, the states could dilute the power of market participants by just increasing the number of non-market participants on boards, including public members. As Steve said, governors should obviously have full discretion when selecting board members rather than being forced to select from industry recommended lists or anything like that. That would inject more public accountability into the process by getting a publicly accountable state representative to weigh in on these decisions. And then, of course, we could eliminate licensing boards altogether or just shift them to an advisory role. We've seen some legislative successes already happening in certain places like Arizona, where the state cosmetology board, was punished for its aggressive anti-competitive behavior, including one example that made the news when a volunteer giving haircuts to homeless people was investigated for practicing cosmetology without a license. The state increased the number of public non-market participants to a majority presence on the board, therefore completely diluting the control of market participants on that board and hopefully decreasing the amount of anti-competitive behavior from that board. At the end of the day, NC has opened a door, and we're the ones that have to walk through it. By strategically targeting captured boards through litigation and advocating for legislative reform, we can dismantle unnecessary barriers to economic freedom. The reality is that antitrust litigation alone is not going to end burdensome occupational licensing, but it can contribute to dismantling structures that enable protectionist behavior, like overburdensome occupational licensing, heavy-handed enforcement tactics like we saw in NC itself, and that sort of thing. A victory in court can delegitimize these boards, create momentum for reform, and ultimately shift power back to consumers and entrepreneurs and the public at large. The goal here is simple. If the government is going to police anti-competitive behavior, it should apply that same scrutiny to its own regulatory bodies, which are some of the strictest monopolies that exist in this country. Let's put this decision to work and reclaim liberty one board at a time. Happy to answer any questions that you have in Q&A. Thanks.
Thank you, gentlemen. Now let's move on to Q&A. This first question is going to be for Caleb, but I do want to state up front that all of you should feel free to jump in or follow up on what everybody else has to say. So, Caleb, have any cases been brought against state licensure boards raising antitrust claims since the NC Dental decision? And if so, what was the outcome?
Sure. When I first looked at this, I was surprised. I'm only aware of around 5 cases that were filed, mostly in the immediate years right after NC Dental was decided by the U.S. Supreme Court. In all but one of those, it seemed like the antitrust claim was kind of like a tack on in response specifically to the NC Dental case. There was one case in Louisiana involving the Court Reporters Board, where it was really a substantive claim. Amazingly, after I think 3 or 4 motions to dismiss that the plaintiffs were able to fend off, including at least 1, if not 2 trips to the Fifth Circuit, the board finally caved and stopped their similar tactics that were occurring in the NC Dental case. But surprisingly to me, at least initially, not many cases, as I think some of the dearth of cases in the last 10 years is kind of explained as Josh and I have looked into ourselves. Even if you get past that, the antitrust or excuse me, the immunity piece, there's still that merits component, and that's really where these cases become resource intensive and much more complicated, especially as boards have gotten a little more wise to what they can't do openly. So the short answer is not many. I think obviously with us being here, our hope is that there will be more, but there's certainly not easy cases to bring.
Thank you. Anybody else? All right, Steve, we're going to step on the libertarian gas pedal here with this one. Why go after the license boards? Why not go after the fundamental problem, which is government licensing itself?
Yeah, I mean, I'm all in favor of doing that too. So but it comes down to, I think, a strategy and a sequencing of that strategy. And let's kind of go big picture for a moment. When we think about economic liberties at the state level, and licensing in particular, right? And of course, Josh and Caleb could certainly speak to this. And I've learned a lot from them, by the way, as a non-litigator about the law and some of this. A lot of the cases, for decades have been based on what they would call 14th Amendment jurisprudence, just the idea that you can have a right to earn a living and things like that. And in fact, quick plug, Cato Institute has a book coming out soon called Beyond the 14th Amendment. And the goal there was to think about how do we defend and argue in favor in courts for economic liberty, but doing so in ways that don't necessarily implicate the 14th Amendment, because there's been a lot of skittishness among judges to kind of read into the Constitution economic liberties in the way they've read into the Constitution other civil liberties, right? They don't really want to equate the two. So that's kind of been a barrier to that strategy. And so the question is, maybe we do something different. Antitrust is one of those ideas, and we have a chapter on that in this book. But I've been thinking more about the legislative strategy, and the idea occurred to me that part of the reason why licensing reforms at the state level haven't gotten very far is because of the boards themselves. They usually have their own budget. They have lobbyists. They're always fighting against even minor tweaks to lobbying board power or to licensing laws, to licensing board powers or to licensing laws themselves are always the first to come out of the woodwork to argue against it. Legislators are often very deferential to them. Effectively, legislatures has given sort of a seat at the table, effectively a political counterweight to what they want to do in the legislature to these boards and to these trade associations that effectively run so many of them. And so it seems to me that if you're trying to sap the political momentum of licensing barriers, getting rid of one of the prime defenders of them in the form of licensing boards might be a good idea. Plus, you get the the ride-along benefit of actually not having all the kind of arbitrary enforcement and conflict of issues or conflict of interest issues that we see. So I'm all in favor of going after licensing laws, but the reason I go after licensing boards is because I think it's easier to get reform licensing laws after the fact once you've gotten rid of a board in that sense.
Yeah, I think
Thoughts?
it's
Anybody else?
important to. I think it's important to note that this is not a comprehensive solution to every problem imposed by occupational licensing boards in general. It's just a way to hopefully reduce the burdens that these boards place on the market, and it's an iterative solution rather than a comprehensive one. It's not the end of the road.
Thank you. This one's for Josh. What unique challenges, burdens do litigants face when bringing an antitrust lawsuit against a state board?
There's actually a couple of things here. I think one of them, a couple of us touched on, which is that the boards are a little smarter these days than they were around NC Dental when they thought they had pure immunity no matter what they did, where they might discuss colluding against their competitors openly. They don't do that anymore. And so the evidence that you have to get for anti-competitive behavior is now circumstantial. And that can require a significant amount of discovery and expensive litigation. But beyond that, it also might be hard to meet the threshold question of whether these agencies are engaging in just basic enforcement authorities that they were given by the state. And so you have to basically be able to use the circumstantial evidence that you have, the patterns of behavior that you have, to push past maybe a reluctant court that would say, well, this just looks like regular enforcement behavior to me. So yeah, collecting that evidence that it's actually going beyond that regular enforcement behavior can be a difficult challenge, but not an insurmountable one.
Great. Anybody else? Okay, next. I'm going to throw this out to all of you. Licensing boards have their power because it's been delegated to them by the state legislature. Is it possible to make a state constitutional case that the legislator cannot delegate such powers? Can other state constitutional arguments be made against licensing boards, such as gift clauses? Or what about the Federal Commerce Clause? Lots of questions in one.
So I think one of the challenges that people face, or especially in public interest litigation, face when trying to use these state constitutions is that oftentimes like non-delegation clauses or principles have been eroded over time. And so this is sort of how Steve put it before, when we've been relying on 14th Amendment claims that are often unsuccessful just due to the low standard of scrutiny that's applied by the court called rational basis. So this is sort of an alternative, or maybe a more likely to be successful alternative to those potential state claims. But organizations like PLF have been trying to breathe life into non-delegation clauses and that sort of thing. And so I would say absolutely those opportunities exist as well.
Anybody else?
I guess I could add. I know this has been subject of some debate, but PLF and some of our other our other friends in the legal movement have also been using the First Amendment, particularly in what some of us call the speaking professions. Some of the benefits of that are real meaningful scrutiny that the courts haven't given under more traditional 14th Amendment causes of action. And those have had very varying levels of successes, but I think we're going to see more cases like that in the future, just as more and more as the concept of what is speech versus conduct is more nuanced and more clarified, that we might hopefully see some positive decisions in that regard. But I know that's been an additional avenue to get at this licensure problem, aside from these other avenues.
Yeah, and actually on the First Amendment thing, I'm glad you brought that up, Caleb, because it reminded me of kind of these cases and just laws about board power to enforce title restrictions, like what you can call yourself, right? So I know there are some cases floating around. I think one of them might be a PLF case, if I remember correctly, where you have someone who's got an MD, a medical degree, but she has a license as a nurse, wanted to practice as a nurse, but because she has the MD, she calls herself a doctor. And the licensing board said, we can't do that. You don't have a physician's license. She goes, well, but I have an MD. That should be enough, right? Everyone calls themselves doctor when they have MDs or PhDs, right? And of course, so these are First Amendment claims, right? Well, does the board really have the power to tell someone they can't call themselves a doctor, even though they have the credential that shows them that? She doesn't have the license. And this again shows you about what licensing laws are really intended to do, in my opinion. They really are meant to basically prohibit people who haven't jumped through the hoops from practicing a specific thing. That's usually true in all of the medical fields, but it's also true in anything that's licensed. And again, these are all issues that come down to the fact that the government is deciding who can or cannot practice in something for reasons rather, other than actual qualifications. It usually comes down to whether you've actually sort of bend the knee to the licensing board. And so again, these are turf issues that can be, I think, sidestepped or I guess alleviated in other ways than just going after the law itself. You can chip away the board power and get some of these arbitrary enforcement actions demeaned, I guess, or just sort of thrown out.
And just real quick, as a point of order, because the case Steve mentioned is one that I am on, just so no one gets the wrong idea. It's not actually that the nurse has an MD. She does have a doctorate degree in nursing practice, which is the highest degree in nursing. But because she doesn't have an MD or a DO or is a licensed physician or surgeon, that's why the state medical board and nursing boards have actually prosecuted nurse practitioners with doctorates for using the term doctor. They've even got tens of thousands of dollars in fines out of one and ran her out of the state. So it's an important case, actually going to summary judgment next month. So stay tuned on that one.
And so the point of order, I refer everyone to my remarks I made before. I'm not a lawyer. So thank you for the clarification, Caleb.
Okay, next. A note here, the American Association of Dental Boards used to be housed at the American Dental Association. Isn't the dental industry already cartelized via the trade associations?
So there's something that occurred to me. So this comes back to the political economy of licensing, right? And so people wonder, well, what happens when you get rid of the board, for instance? Yeah, in the alternative universe where libertarians can wave their magic wand and get rid of these licensing boards, does that really mean that unlicensed dentists, like the guy from Little Shop of Horrors or something, are they going to be drilling people's teeth and getting themselves high on laughing gas and wreaking havoc on people's gums and mouth? But no, especially in the medical fields, there already is kind of a form of credentialization, right? And so this is not going to go away. And so while I would call it a cartelization of a sense, but I think the real risk of cartelization comes with when you embed that power to enforce that cartel in a licensing board, right? Because you can also imagine a world in which, okay, let's say it's a non-medical profession, right? And you are an interior designer. So maybe this is a good example because interior designers are not licensed in many states, although some legislators want to make that true, that they are licensed in some states. But there actually are national trade associations that give out what you might call a good housekeeping seal of approval. There's certain credentials you can get. And you go through courses, you go through some kind of curriculum, and then the national industry association says, you now have this credential. And you can tell people that. And you can show that you are a qualified professional, even if there's no license. And so people often, I think, confuse license with credential. What license really is just a permission slip from the government to do what you already know how to do. What a credential is, it shows people that you know how to do that thing. So I'm all in favor of putting more weight on the credential part of it and less weight on the license part of it. And again, the way you do that is get rid of licensing laws altogether, or you just make licensing just another form of a credential that might just be optional in certain cases, right? So again, we talk about this in medical professions and non-medical professions, but there do seem to be a variation of credentialization that might serve the same purpose that licensing laws are intended to serve, but without all of the negative impacts.
Yeah, if I could jump in on that, one of those negative impacts I've been following over the last several years, things like art and music therapy are it's a growing field. The degree programs then require you to get those private certifications to be able to work in that field, and that's all fine, all well and good. But what you're seeing is there's this increasing push across the country to then also create the license. But when you look at what the license requirements are, it's just you have to have the private certification. So what is the licensure actually adding? Certainly nothing from a qualification standpoint for the actual practitioner, but it is, as Steve said, just creating this government permission slip. And if you don't have it, you can be in a world of hurt as a practitioner, but also, more fundamentally, that just means there are fewer people available to practice that profession or trade in the state. And ultimately, it's the public that's hurt by having fewer options, and the options that are available are necessarily going to be at a higher cost.
Thanks, gentlemen. We've only got a couple minutes left, I believe, and getting a lot of questions that I think is great. People want to get involved. So let me just throw these out to you. Who is standing to pursue a public interest lawsuit in this area? How can I start the process to get a public statute changed for participation requirements on occupational licensing board? Are there any model bills out there? So other people want to know how can I help bring about a case in my state? What would you all say to these questions?
I'd say for the standing question, anyone who's injured by anti-competitive board behavior would have standing. So an individual business or practitioner would be able to bring a lawsuit plausibly.
And I'll
In
just
terms of the
plug
model
myself and
bill,
Josh.
oh, go ahead.
Just real quick, Steve, I'll just plug myself and Josh that if you are someone who you think has standing, we would be happy to hear from you if this is a real problem that is affecting your livelihood or your potential livelihood. We'd be happy to talk with you. But sorry, Steve, go ahead.
That's okay. And in fact, there is a model bill for the nominee components. Remember when I talked about how a governor can only choose from a list of names that's been given to him by the trade association? There actually is a model bill that Pacific Legal Foundation put forward in a report that I wrote about this a few years ago, which I'm sure we could furnish in a blog post at Cato at some point or send to participants. The idea is that it basically just it reinstates the governor's power. It sort of ratifies and sort of confirms the governor's power to use their constitutional office to make the kinds of nominations rather that they think are important without they can get advisory advice, so they could get a list from an association, but they don't have to do anything with it. They could, but they don't have to. And so that's really what the model bill would say in a nutshell. It's actually a fairly simple tweak, but it could go part of the way to alleviating some of the things that we talked about today.
One more question. Should we be concerned about the federal government using federal antitrust law? Isn't that like playing with fire, given its abusive usage against private interests?
I've
Tad, you
answered this
waited till
question.
we have 1 minute left to answer like the biggest question. Yeah, go.
So I've addressed this question before, just because the concerns are legitimate. Antitrust policy applied against private businesses has been catastrophic, in my opinion. I don't think that's even overly dramatic to say. Extremely costly, protective of lethargic companies that don't innovate, that sort of thing. However, antitrust law is not going away anytime soon. The Supreme Court has referred to the Sherman Act as the Magna Carta of free market, or a free market system, or competition system, or I don't remember the exact quote, but something like that. And so since it isn't going away, I feel like we might as well use it for its only pro-liberty application, which is reining in the greatest monopolies that we have in this country, which are our government run.
Can't really add much more to
Beautifully.
that, Josh. Thank
I
you
was
for the
going to
mic
say
drop.
that's a pretty beautiful way to end this, Josh. Thank you. Bravo, sir. Thank you, everybody, for joining us today. I hope you found it interesting and enlightening. It's an important subject, and please visit our respective institutions for more. Cato Institute and the Pacific Legal Foundation. Thank you. Bye-bye.